Hello, everyone. Welcome to a new episode of American Spaces on our podcast brought to you by Instituto Chileno Norteamericano and American Academy of Science and Technology of Universidad de Texas, in collaboration with the United States Embassy and the American Spaces Network in Chile. My name is Juan Miguel Romero, Director of American Space Santiago, and joining me today is Nicole Belay, Coordinator of American Academy of University of Talca. We will be your hosts today. Today's topic is all about intellectual property rights, or IPR for short. It might sound technical, but it's something that touches our everyday lives. From the apps we use on our phones to the music we listen to, and even the medicines we rely on. At their core, intellectual property rights are about protecting ideas and innovation. They give inventors, artists, and creators a chance to benefit from their work, while also encouraging new discoveries that help society move forward. Without them, innovation can slow down, markets can become unfair, and creators may lose the value of what they've built.
To help us better understand this fascinating topic, we're joined today by Dr. Vanderhart. We're excited to welcome you to Chile and to have you here in our podcast, Our American Spaces on Air. Thank you. For our listeners, Dr. Vanderhart is a PhD economist and the managing director at Secretariat, a consulting firm based in Washington, D.C. that specializes in economic and litigation services. Dr. Vanderhart focuses on the economics and valuation of intellectual property rights.
Dr. Van, it's a pleasure to have you here. How are you?
Very well, thank you. I'm happy to be here.
Um, you are an expert in economics and valuation of intellectual property rights. For those who aren't familiar with the term, how would you explain that, or what they are to someone sitting next to you on a metro ride downtown, for example?
Well, I think in part that would depend on how long that metro ride was going to be. But I think just the term intellectual property and intellectual property rights can be confusing. Many people are familiar, though, with individual pieces of intellectual property. So it includes patents, copyrights, trademarks, and then other information like trade secrets and other confidential information that a company or a person might own. Um, they're the rights that the owners of these assets, and they are assets, and it's the rights that they have. So, what are your rights if you own a patent, if you own a trademark, if you own a copyright? More and more of the assets of a company these days are intellectual property assets. So, it used to be that it was all hard assets, it was all products. And these days, the balance sheets of a company, or many companies at least, are largely made up of these intellectual property assets. And protecting those assets and being able to maintain control of those assets is a key factor and very important to the profitability and success of those companies. Many people, for instance, are very familiar with the highly protected formula for Coca Cola. That's a trade secret. If you look at your phone, there's any number, hundreds, maybe thousands of patents that cover all of the different aspects of your phone. So those are patent rights that companies are going to hold and want to protect. Trademarks will also be on your phone. There's probably a logo there. There's other aspects when you turn it on that will cover trademark rights. And then copyrights cover many different things. It covers art, it covers publication, it'll cover music, just to name a few.
Wow. That sounds like something that affects pretty much all of us and the products and service we use on a daily basis, actually.
Yes.
How did you get into this field? What it makes it interesting for you, and what did you study, and how did you evolve to get this expertise?
So I got my undergraduate degree in economics and Spanish, actually, with a minor in math at Trinity University, which is in San Antonio, Texas. And I worked for a couple of years at a consulting firm after that, and then went on to get my PhD in economics at Texas A&M University, which is in College Station, Texas. And my dissertation was in the field of industrial organization. An industrial organization covers these types of topics. It looks at the way that markets and firms organize. And part of that also looks at the way that they use intellectual property, whether intellectual property is vital to the success and performance of that particular industry or that particular firm. And while I was getting my PhD, I was working at a consulting firm and I finished my PhD. I thought I might go into academia, but it just didn't work out that way. I stayed in consulting. Um, and part of that trip, that life trip, I guess, is what opportunities are given to you. And I started working on intellectual property matters, and they were very, very interesting. I got involved in organizations that deal with intellectual property and became more and more involved in those, and it just kind of developed from there.
Perfect. So it was all like a trip that you didn't plan from the beginning. It just started happening.
Exactly. It just kind of happened organically. That's where my life and
I
opportunity.
know you're here in Chile talking
Yeah.
about ITR. So for our audience, let's make a, let's say, real. Well, it's actually an imaginary example, but something that people would probably understand better. Let's say that I'm a toy inventor in the U.S. and I've created a toy that is covered by a patent. But I discovered another inventor has created something that looks suspiciously like they stole my invention. They insist that they didn't. How would this dispute be resolved in the US?
So, usually the way that I've seen it happen, and there's many different ways, of course, that this could progress, but the inventor or probably their lawyer will send a letter to the infringer, the accused infringer, and say, hey, looks like you're infringing our patent. They'll give them a copy of the patent or point it out to them and say, we think your product may infringe this patent. Maybe there's a response, maybe there's not a response. That'll go back and forth a bit. Maybe if there is a response, they manage to come to an agreement. Either they can show that they don't infringe it and everybody agrees, or they can't. And maybe if they can't, they come to an agreement on an amount that'll be paid, a royalty payment to the inventor. And if that doesn't happen and the inventor still thinks that they infringe and they still think they don't, usually that's around the time that a lawsuit's going to be filed. And so they'll file a patent infringement lawsuit and the case will go through the court system. And in the States, that'll take, it seems like a minimum of 18 months to 2 years. And it can be much longer than that, depending on the complexity of the patent, depending on which district you file in, depending on many different things. And there's various things that you have to go through. I'll be brought in at some point in that process as a damages and valuation expert by one side or the other. And so usually both sides, plaintiff and defendant, will hire their own technical and their own damages experts. And we will, as the damages expert, look to see, I assume infringement. So what happens? I'm going to assume they do infringe.
Yeah.
That has to be proven in court.
Yeah.
But as your damages expert, I would say if they infringe, this is how much they ought to pay.
Okay.
And usually these things will settle before they actually get to a trial. So very, very few patent cases, especially, actually go all the way to trial. It's very expensive to go to trial. It's very uncertain. So usually they settle.
Yeah, and as you said, it takes a lot of time.
A lot of times.
So as an expert, you would also, if you see from the, I don't know, evidence that you have available, you could also make a decision. Okay, maybe this doesn't look like they infringe. You would also say that to the person who
So
reached out to you.
I'm the damages expert. So I probably would not be making those sorts of decisions.
Okay.
There's a technical expert, an infringement expert, and they're the ones who are going to be opining on what they call liability. whether or not it does or doesn't infringe.
Perfect.
But as the economist, as the damages expert, that's kind of outside my area.
Okay, detail.
Well, Jennifer, after listening to your professional career, we can say that you have worn and continue to wear a lot of hats. You're a teacher, you're an advisor, an author. You also have an extensive background in both domestic and international arbitration cases and litigation in the US courts related to IPR and the valuation of intellectual property. Can you share an example of a case that the common person might relate to? What went wrong? How was valuation involved? And how did courts resolve the dispute?
Sure. So I had kind of an interesting case that went to trial a couple of years ago on behalf of Moonbug, and Moonbug owns the kids show Cocomelon. So if at least in the States, if you have children, if you have young children in the past 10 years, you probably know Cocomelon. It's one of the top YouTube channels. It was number one for a while. I think it's still maybe number two or three. So it's a big show. And the defendant was a company called Baby Bus. And Baby Bus had a show they called Baby JoJo. So the protagonist in the Cocomelon show, Baby JJ, and then the show by Baby Bus, Baby JoJo. They were very similar, the same family structure. The babies looked very similar. The first few shows that Baby JoJo put out were exactly the same as the Cocomelon shows. And then they went off and they used the same characters, but the shows were slightly different. And Moonbug accused Baby Bus of infringing 42 copyrights associated with the Cocomelon show. And again, it went through the entire process, all the depositions, all of the motions, and it did get to trial. And meanwhile, the attorneys were filing takedown notices. So in the US, through the DCMA, you can file a takedown notice and the show will be pulled off of, in this case, YouTube. Now, Baby Bus and Baby JoJo, they countered and said, no, our shows don't infringe. And so many of the shows were put back on. And that's when you get to the litigation stage, when they say, wait, we still think you infringe. We don't think you should have those shows on. And so what I was brought in to do, of course, as discussed, was to calculate the damages. And in that particular case, they were twofold. So the damages were, number one, which of those shows that Baby JoJo showed would have instead been views for Cocomelon. So this is YouTube, the way YouTube makes money, of course, or the way you make money on YouTube as a content provider is to get views. And you get views, you get money.
Yeah.
Yes.
And so if Baby JoJo's there taking some of the views, then Cocomelon is getting less money. But there's lots of kids shows on YouTube. And so we couldn't just assume that every Baby JoJo view would have been a Cocomelon view. So we had to figure out how many of the views would have been Cocomelon views. And Cocomelon gets its own lost profits from those views. And then the other piece is the views that wouldn't have been Cocomelon views in the U.S. court system or in the U.S. legal system. Cocomelon gets Baby JoJo's profits off of those views. And so it was kind of a two-part damages analysis. Like I said, went all the way through court. There was a jury. The jury heard all of the testimony, and they determined that 39 of the 42 copyrights were infringed. So almost all, and they awarded about that percent of the damages that I had calculated. So a victory certainly for Cocomelon. They got interest on top of that. They got attorney's fees on top of that. And now they have appealed. So Baby JoJo, I think, has appealed that decision. But as of now, that is where it stands. So it's an interesting.
Thing. And how long did it take, that case?
Oh gosh. So it was about a 2-week trial itself. But I think the entire process, oh gosh, from start to finish, it had to have been at least 3 years, maybe longer. I should look back at that. I don't know exactly, but it was a long time, yeah, going from one to another.
Very interesting.
Wow.
It took a while.
Like to understand the trade-off,
It's very expensive. Attorneys are expensive. Experts are expensive. There's lots of experts, lots of
Yeah.
attorneys, both sides.
I think you have to be sure that you want to go through that
You
to
absolutely do. You
go through the
absolutely
lawsuit.
do. And that's why so few cases get all the way to trial, and most of them will settle prior to getting that far.
Mm. Now, talking about the local context, over the last 20 years, Chile has made major moves to expand and improve its IPR system, including opening the National Institute of Industrial Property, known as INAPI, in 2009. Part of INAPI's vision is to increasing the productivity and diversification of the country's economy. Can you share how intellectual property rights benefit the economy?
So at a very high level, of course, if an inventor is not able to earn profits or get the benefits, the full benefits of their invention, then it's going to reduce their incentive to invent, their incentive to innovate. And one change that occurred in the past couple of decades, as I mentioned, is that that is where they are making a lot of their money, is where they're getting their value is through these intellectual property assets. And so if you take away the benefit of investing in the research and development that leads to those intellectual property assets being developed, you're just gonna reduce the innovation, you're gonna reduce invention, and innovation and invention lead to higher productivity, and so without the incentives to do that, you just lessen the benefits, like I said, that they get from that R&D, and you reduce the R&D that's gonna be created in the country, and one of the things that INAPI has done is put into place, provisional patents, and I think that is one of the things that is going to help, especially some of the smaller inventors, um, be able to,
Yeah.
quite frankly, get a patent and invent more.
Yeah. Yeah, so having a good like legal framework in the country for IPR boosts the economy in the sense that people or inventors or private companies would be encouraged to keep doing it,
Absolutely.
to bring more to the table.
It takes many years, so research and development may have to start years before an invention actually can
Yeah.
be commercialized. And so you have to be pretty sure that at some point, if you put all of that investment into your R&D and you do discover something fabulous, that you can commercialize that and make it profitable. If not, you just spent a whole lot of money in R&D, you come out with an invention, someone else steals it or copies it, then how
It's
do you
unfair.
it's unfair and quite frankly, you lose money. I mean,
Yeah.
there's no way to sustain that.
Perfect.
And so, on the flip side, how can weak IPR protections be harmful to both individuals or organizations, even nations, as you said? How could it be? Like,
No, absolutely. So on the other side, if you don't have strong IPR protections, then you aren't going to have that innovation. You're not going to have that invention. And the other fear that I think does sometimes come true is not only will you not have it, the people, those smart people who are inventive in doing that, they'll leave. And so they call it brain drain. Right. They'll go to other regimes where you do have stronger IP protections, where their intellectual property will be protected, where they can commercialize it and get the benefits from all of that research and development, all of that upfront investment that they're going to have to make.
Yeah, in the scenario of, small inventors, as you just mentioned, what would be your best advice for them, or creative inventors who is producing something new and innovative, but doesn't have a lot of money to spend on lawyers to protect their intellectual property because, as you said, it's really expensive. What path should they take to best protect their invention?
So it can be, protecting your intellectual property is so important. And keeping keeping it secret is important. And so if they are inventing something, whether it's a patent, whether it's a trade secret, those sorts of things, you do have to keep it kind of close to the vest and set up protections so that it isn't widely known. And I mentioned that INAPI here in Chile has put into place this provisional patent system. And so that's a little bit of a shortcut. You still have to do something, of course, to file that provisional patent, but it gives you a year to kind of formalize and complete the patent application, kind of put the full patent application into place, which might take a little more time. And I know, just like in the States and Chile, there's organizations that can help you do that.
Yeah.
So there's a lot of organizations that will help startups that might provide services at low cost or maybe even no cost, depending.
Yeah.
And so, do your research, look into what is available. You've done all the research to actually invent something. So now do the research you need to protect our attention as well.
Well, and that's why we have this kind of shows. Thank you, Dr. Vanderhart, for joining us today. It was really interesting, everything you just mentioned.
My pleasure. Happy to be here.
Thank
So you're touring both.
Educating us and people, and not just inventors, but sometimes it takes some time to someone just to make that step and then create something that they have tried maybe, but they're not encouraged enough to make this happen.
Absolutely. You have to reach out to our inventors.
Well, we've reached the end of our episode. Thank you all for watching and see you in the next time. Bye.
Thank you.
Bye.
Hello, everyone. Welcome to a new episode of American Spaces On Air podcast, an initiative brought to you by the American Space at Instituto Chile Norteamericano of Santiago and American Academy of Science and Technology of Universidad de Talca, in collaboration with the United States Embassy in Santiago and the American Spaces Network in Chile. My name is Juan Miguel Romero, Director of American Space Santiago, and joining me today is Nicole Belay, Coordinator of American Academy of Science at Universidad de Talca.
Entonces era solo esa parte, la inicial.
Era la parte inicial,
Ya, ok.
para que nos pidieran un poco más lento, pero era solo eso.
¿Lo hice más lento, lo hice bien?
Sí,
Perfecto, perfecto.
Gracias.
muchas gracias. Gracias a ti, a Yoli.